Welcome back, friends. This will be our last class on the topic of Insolvency Bankruptcy Code 2016, where we'll conclude with the remaining provisions of the code along with few practical and so by this time, I believe you must have gone through them, which is very important so that you have a fair idea what we have discussed so far, and the questions, the sections which we have covered, and the relevant exam questions which are asked in the exams. So if you have any questions, do please raise it so that I can answer the same. And just a quick recap of what we have studied in the last two classes. Remember, we had started with the Insolvency Bankruptcy Code 2016, the need, the reason why this code was introduced in our country. And remember, IBC code is not a compliance, but it is a solution provider law where it brings a resolution for all the companies which are under stress, which have made a default for all the loan, financial debt, or the operational debt. So if people who have logged in can send a message so that I can understand and accordingly take it forward. So I'm waiting for your communication. So, friends, we had covered the various provisions, and in the last class we had left at the liquidation part. If you remember liquidation, we had covered the liquidation angle. Why does the corporate debtor goes into liquidation, the reason of going into liquidation, and how the NCLT will give an order of liquidation, which is very important to be understood, that under what circumstances the liquidation order is given by NCLT under various provisions of the code. Right, and then the power of the liquidator, the incorporation of the liquidation state, where the liquidator will include all the assets of the corporate debtor, what is not to be included in the liquidation state that we had discussed, and the process of claim. Then section 52 and 53, which was very important, which we had understood the waterfall mechanism, which is the crux of our whole IBC, because a lot of references are there, and in the event of liquidation, how that amount will be distributed, that is very important. Now, friends, there are certain angles which are not covered under your course content, but which are very relevant for liquidator. So I'll just give you a brief understanding in short, so that we all understand that, though the sections and the rules have been framed, but we should know how the whole process is carried on. So as a liquidator, because there's no mention of committee of creditors in this whole process of liquidation. So there might be a question in the exams, what is the role of COC in liquidation? Though there is no reference of COC, but is there any role of COC under liquidation? So somebody should have raised this point, sir. Is the liquidator only the sole authority to take all the decisions? So friends, remember, under liquidation, there is no concept of COC. There is no concept of COC. But does that mean that liquidator will only perform every function without taking permission from any of the stakeholders? So under liquidation, there is a concept of SCC, Stakeholder Consultation Committee. Stakeholder Consultation Committee. Remember the role of SCC, Stakeholder Consultation Committee. That is the job, and the COC will be replaced by SCC. So is the constitution of SCC same as COC? The answer is no. Answer is absolutely no. The SCC will comprise of, obviously, remember in COC there is a a financial creditor who holds the major position in the COC. In the same way, there will be representation of financial creditors, then unsecured financial creditors, and then you will have representation from operational creditors, workmen, employees. That means for each class of creditor, there will be one representation. There will be one representation, remember. So the SCC will comprise of all the stakeholders involved. It is not individually the financial creditors only, remember. So the liquidator will perform his duties in consonance with the SCC committee. Now, when I say in consonance, it does not mean that for everything he has to take an approval of SCC. But again, a prudent liquidator will always follow the instructions of the SCC, ultimately because they are the stakeholders involved in this whole process. So liquidator has been given a power to act on his own, take decision on his own, and perform his duties. But simultaneously, the SCC is going to monitor his activities. And it is suggested that all approval, at least on the major things, should be taken by the SCC, though not binding on liquidator. Though not binding on liquidator. That is the important angle. So all decisions of SCC will not be binding on the liquidator. And if there is a difference, it should be recorded in the SCC minutes. So again, as COC meetings are held, here SCC meetings will be held, and all the decisions will be approved by the SCC, and accordingly the whole process of liquidation will be carried on. Now, what is the major decision which the SCC has to take? So first, we have seen the formation of liquidation state by the liquidator. So obviously, the liquidator will compile all the assets of the corporate debtor. And now, the major challenge which will come to the liquidator is to dispose of those assets. So as per law, there are various mechanisms of disposal of the assets of the corporate debtor. Now remember, the prime difference between CIRP and liquidation is, under CIRP, the whole company is being sold and the resolution applicant will buy the company, not the individual assets. So under liquidation, will the same thing happen or not? Or is there a different mechanism? So under liquidation, as per law, it is mentioned that the first attempt of the liquidator should be to sell the company as a going concern. That means whatever we have seen in CIRP process, the same could be followed under liquidation also. Except that there will be no resolution applicant, there will be no expression of interest, but here the bidding will be done. Selling the company as a going concern on as it is, where is it basis. So that means here also the company will be sold accordingly, and the buyer will buy the company as a whole, and accordingly he will take the necessary steps. Here there is no approval required of the COC of 66% voting. Remember, it is through a bidding process. Whoever bids at a higher value will take away the company as a going concern. And if that attempt fails of selling the company as a going concern, then the SCC and the liquidator may decide to sell the assets, individual assets, through an auction process. So the major job will be to create the liquidation state, and then second job is to sell the company as a going concern and sell the assets. So the assets may be sold off individually, land and building may be sold separately, plant and machine may be sold separately, individual assets could be sold separately. So that could be a process followed by the liquidator in consent with the SCC committee. It could be sold through a public auction, and if the public auction fails, then there could be a private sale also. It could be sale in parts, piecemeal basis. Whatever could be the best possible way is to realize the amount and distribute it to the stakeholders as per section 53. So once this is done, which is to be completed within a 1 year time frame, then the whole process will come to an end. So in difference between CIRP and liquidation could be what? Will be what? The first difference is there's no role of COC. There is no requirement of getting an approval of 66% for approval of the resolution plan or selling the company as a going concern, because it is purely based on the highest bidding, and the bidding is done through the e-auction mechanism. And based on that, the company could be sold. And obviously then the routine process of expenses, incurring the expenses, getting the approval of SCC will be done. And a lot of responsibility is casted on the liquidator to give certain information, inputs, reports to adjudicating authority from time to time, starting with an preliminary report, submission of the information to the adjudicating authority, and then progress report to be filed quarterly with the adjudicating authority. So a lot of monitoring is done by NCLT, and therefore the job of the liquidator is very tedious at times, because he has to ensure that the assets are accumulated, sold, and then finally the amount has to be distributed. Now, when the assets are sold and the amount is received, there will be a process design that you have to submit the amount between these many days. And once the amount is received, the amount has to be distributed within 90 days. Amount has to be distributed within 90 days. Yes, Mancha, it will be done today, tomorrow, with whatever we have studied so far. Right? Good evening, Janvi. Yeah. So first difference, COC, SCC. Second difference is the consent of SCC at every step, which may not be required, and the liquidator can perform on his own. Obviously, if there's a difference, that has to be recorded. The first effort under CIRP, remember, the company is sold as such as a going concern. In liquidation, the first attempt would be to sell the company as a going concern. And if the SCC decides otherwise, if they think that it is not required to sell the company as a going concern, they can record the same, and then the liquidator may directly sell the company in parts. The assets could be sold in parts, and the mechanism of selling the assets could be decided by the SCC. There are four to five mechanisms which have been given under the law. Based on those 5 steps, 5 mechanisms, the company could be sold. And whatever amount is collected as per the law, within the time frame as devised, the amount will be received. And if the highest bidder fails to submit those amount, then the EMD which has been deposited by him for bidding, that could be forfeited by the liquidator. And thereafter, once the amount is received, within 90 days, the amount will be distributed as per section 53 mechanism. Now, an obvious question, being a professional, so what is the fees of the liquidator? What is the fees of the RP? What is the difference between the fees of both the people? So remember, friends, the fees of the RP is laid down in the law itself. And that has been brought into by an amendment in 2022. Prior to that, it was left to the COC to decide. So that means it was more of a negotiated deal between the RP and the COC. So a lot of disputes used to arise. And thereafter, the law came into force that yes, the fees will be as per the amount of claim received. So there is a table given, and based on that table, the fees of the RP is decided. That is the minimum fees which has been prescribed. Obviously, you can go for a higher fees. Plus, there is a mechanism of incentive also based on the resolution amount, which may come to the RP also. In case of liquidator, again the fees may be determined by the SCC. the fees may be determined by the SCC. And if not determined, they can apply, they can go as per the regulation. So again, there is a table given under regulation 44A of liquidation regulations, where the fees which is to be paid to the liquidator is prescribed based on the amount which is realized and amount which is distributed and the time frame. So if you realize the amount within 3 months and you sell distributed within 3 months or 6 months, your fees is higher. And then gradually, if the time period exceeds, then the fees gets lower. That is on the percentage of the amount received and amount distributed. So RP fees is fixed, liquidator fees is fixed. That means he did not worry about his fees, because again, remember, as per section 53, as per regulation, all these fees are part of CRP cost. And remember, the first item under section 53, which is provided for in waterfall mechanism, is payment towards CRP cost. That means your fees is secured. There is no doubt that you will not receive your fees, and it will be received in the first instance. So that is how, friends, this whole process of CIRP and liquidation goes on. And the difference between the CIRP and liquidation, I have given you certain examples on what could be the possible difference. And obviously, time frame is one of them, where different time frame is maximum 330 years, it is maximum 1 year. And during this process of liquidation, there could be other issues which can crop up, and that has to be handled by the liquidator. So I hope it is clear, the difference between CIRP and the liquidation. In brief, I have given you the major point of difference. Now, yes, one point. Now, when will be the SCC formed? Remember, this COC is formed within 30 days. The first meeting of the COC is held within 30 days. Here, there's a time difference of time period that within 30 days, the claim will be received. And then within 60 days, he has to form the SCC. So there is an extended time period, because in liquidation, the time frame is 1 year, and a lot of time is given to all the claimants to file their claim. But the rule says that within the announcement or the order of liquidation, the liquidator has to call the first SCC meeting within 7 days. Now, the claim will be received in 30 days. I have to call a meeting of the first SCC within 7 days. How is it possible? So the rule says that the SCC meeting can be called on the basis of claim received during CRP. Claim received during CRP. So there are certain laws. I will not go into details of those laws. There are a lot of regulations. But yes, you should be aware of the major differences between CIRP and the liquidation process. So last time we had left at the stage of this, and I had given certain hint of PUFE transactions. So let me today cover all those PUFE transactions. Now remember, friends, these are all referred to as, again, recalling the word, avoidance transactions. These are all avoidance transactions referred to in various sections. And these are transactions which are entered by the old management, where there could be a preference given of fraudulent transactions or undervalued transactions. Why these transactions are to be reported by the RP or the liquidator? Remember, the responsibility has been casted on the RP and the liquidator to report on the same. To report on the same. To whom? To NCLT. To NCLT. That these are the transactions which have been undertaken by the old management, which is in violation of section 53 or where there are certain gross negligence in these transactions. Therefore, these transactions should be called back or should be declared null and void. So what are those transactions? The first transaction is a preferential transaction under section 43. Preferential transaction under section 43. So what is that preferential transaction? There is a transfer of property, first transaction, or an interest thereof. So the interest is transferred of the corporate debtor for the benefit of a creditor. So the benefit is given to a creditor or a surety, that means a guarantor, on account of an antecedent financial debt and operational debt or other liabilities owed by the corporate debt. Antecedent means old financial debt or operational debt. So you transfer a property, let's say you have taken a loan, and after taking a loan, you have transferred a property, creating a security, creating a secured loan, or you are creating a security interest. And the transfer has the effect of putting such creditor, or a surety or a guarantor in a beneficial position than it would have been in the event of distribution of assets. That means because you have transferred that property, that particular person is now in a beneficial position. For example, there was an unsecured loan, but because you have created a mortgage, you have transferred a property or created an interest thereof. By virtue of that transaction, that loan has become secured from unsecured. And we have understood, we have studied section 53, where secured creditor are given preferences over unsecured creditor. Therefore, you would be getting priority in payment, which should not have been done. So these transactions could be treated as preferential transactions. Preferential transaction. So remember, there is a transfer of property or a beneficial interest thereof, and this transfer is putting that particular creditor in a beneficial position. That is the major criteria to decide whether that is a preferential transaction or not. Now, obviously, there could be certain transactions which are in the ordinary course of business of financial affairs. For example, or any transfer creating a security interest in property acquired by the corporate debtor to the extent that such security interest secures new value. That means you are transferring a property, but because of that transfer, you're getting new loan, which is very logical. So then such kind of transfer would not be treated as a preferential transaction. So there are conditions that which are in the ordinary course of business or financial affairs of the corporate. That was, it was its business to sell the assets. Selling land was their business. So obviously in that case, it would not be treated as a preferential transaction. Creating a security interest, and because of that I am creating new loan, then it will not be treated as a security interest. And any transfer made in pursuance of an order of court shall not preclude such transfer to be deemed to as given with preference by the corporate debtor. So if it is done because of virtue of any order of court, then it shall not preclude such transfer to be deemed as given of preference by the corporate debtor. It will not be deemed that it is a preference which is given. So remember, in exams, exceptions are generally asked in comparison to the normal provision. So under what cases the transaction will not be covered as a preferential transaction? So this is section 43. Now, what is going to happen if you find a preferential transaction? So you have to give an application, file an application to the court that yes, these are preferential transactions, and Janvi, it is again converting an unsecured creditor to secured creditor will increase his liability and is not mandatory. Remember, because the intention is that you want to make it a secured creditor. Because you know there is a problem going on with the company and the company may go under stress or may go under IBC, and that is why you have made a transfer, just to ensure that he will always get a preference. And that is why the transactions are referred to the court that these transactions should not have been done. I hope you got the point. Now, when these transactions are reported by the RP or the liquidator. Now, remember, how will RP come to know? Obviously, he will apply his own due diligence of understanding the transactions, evaluating the transactions, and then finding out those kind of transactions which could be treated as a financial preferential transaction, or he can appoint a transaction auditor or a forensic auditor to find out such transactions. That is a possibility. So once he comes to know of this transaction, he will file an application to the court, and NCLT will, by an order, require any property transferred in connection with the givens of preference to be vested to the corporate debtor, or, very important, require any property to be so vested if it represents the application either of the proceeds of sale of the property so transferred or of some money so transferred. That means if the property has been sold off by the other person, then you have to transfer the money. Or if a security interest is created, then release that security interest. If you are receiving any benefit out of that property, that please transfer that benefit also. And direct any guarantor whose financial debts or operational debts owed to any person were released or discharged by the giving of preference to be under and such new or revived financial debt to that person as the adjudicating authority deem appropriate. That means it can give a direction to the guarantor whose financial debt or operational debt owed to any person were released or discharged by giving of the preference. That means if the guarantor is owing certain kind of debt and you have transferred a property to any particular third party, because you have transferred a property because he was a guarantor to your company, which X was supposed to give to A, because Y has transferred certain property to A, and Y has done it because X is a guarantor to the loan taken by Y Limited. So the court will direct the guarantor that please reverse this transaction, or whatever amount of that loan has been, whatever amount you have been waived off by A, please transfer that particular amount or get the property released to Y Limited. Then further, what will be done? The NCLT can give direction for providing security or charge on any property for the discharge of any financial debt or operational debt under the order, and such security or charge to have same priority as the security or charge released or discharged wholly or in part of the giving the preference. Which means that if any security has been or charge has been created for discharge of any financial debt, and such security or charge whichever has been created by virtue of this transaction, to have the same priority, as the security charge which has been released because of this particular preference, because this property has been transferred as a preferential transaction, then whatever charge was in existence prior to give this transfer, same charge should be in place to this particular property also. There should not be any difference. But very important, under this, the order under this section shall not. Suppose A has transferred to B Limited, and this is treated as financial transaction, a preferential transaction. But B has transferred this asset to C Limited, and C Limited has bought this particular property from B Limited purely in good faith and for value to be pay a sum to the liquidator or the dissolution professional. This has been done in good faith. Then the NCLT cannot give direction to C Limited to give that amount to A Limited. Order cannot be given to C Limited. Order can only be given to B Limited to deposit that amount. But remember, if C Limited had sufficient information of the commencement of the insolvency process, then it cannot be treated to be have done in good faith. Or if C Limited is a related party. If these are the two situations where C Limited was aware of the fact and C Limited is a related party, then we'll assume that it was not done in good faith. So a lot of complications, friends. It's not an easy to prove a preferential transaction because what we have seen, there are a lot of cases which have been pending under the law, which are filed against. Now remember, these transactions will be filed against whom? Application will be filed against the person who has entered into the transaction, and yes, obviously against the suspended management who has entered into this transaction. So a lot of cases are pending and the process goes on for a very long period because it takes time to prove that it is a preferential transaction and it has been done other than in the normal course of business. So 43 is defining the preferential transaction. 44 is in making an application and the NCLT giving certain kind of orders for their preferential transaction. Now coming to undervalued transactions. Undervalued transactions. Now what are undervalued transactions? Such transaction has not taken place in the ordinary course of business of the corporator, where the transaction is making a gift to a person or enters into a transaction with a person which involves the transfer of one or more assets by the corporator for a consideration, the value of which is significantly less than the value of consideration provided by the corporator. So simple, you have transferred an asset at a less price or you have gifted the asset. If that is done, then it is treated as an undervalued transaction. So preferential is where you have given certain preference so that he jumps up the ladder of section 53 or you have transferred an asset at a lower price than the market value of that particular asset. So the question comes in, what is the time period where I have to look into these transactions and find out whether those transactions fall under this criteria or not? Can I refer to transactions taken place in 10 years back, 5 years back, or is it only the recent transaction? So section 46 gives the relevant time period for such kind of transactions. And it talks about a transaction between two parties, either related party or unrelated party. So if the transaction is done between a related party, other than by reason of only being an employee, then 2 years preceding the insolvency commencement date. And if it is unrelated party, during the period of 1 year preceding the insolvency commencement date. So obviously, if it is a related party, you will go back more and find out whether in last 2 years, whether these transactions have taken place or not. So again, in exam, there could be a practical question asking for the time period. Now remember, it is preceding the insolvency commencement date, not the initiation date. And I hope the difference between initiation date and the insolvency commencement date is clear to everyone. Where initiation date is where you have filed the application and commencement date is when the NCLT gives the order. So for 45, the order which the NCLT may give require any property transferred as a part of the transaction to be vested in the corporate debtor. Please give back the property to CD, or release or discharge any security interest granted by the corporate debtor, or require any person to pay such amount in respect of the benefits received by such person to the liquidator, the RP, as the case may be, as the AMA or direct. That means any benefit which you have received because of the transfer of the asset, you should have to transfer that benefit, and require the payment of such consideration for the transaction as may be determined by the independent expert. So an independent expert may come and find out that this is the actual value. Please get that actual value transferred. And if referring to these type of transactions, I can go on and explore the possible opportunities and complications. But anyway, that may be outside our purview at this stage. So 43, 44 club together. 45, 48 club together. 43, 44. 43 is conditions, 44 is the order, 45 is the condition, 48 is the order. 46 is the time period relevant for both 43 and 45. 46 section is the time period relevant for both 43 and 45. So application by RP or liquidator, order will come under 44 or 48. Then there is one more section, which is again a different section, exceptional section. So again, this could be asked in the exams. An application by a creditor. And it says that where an undervalued transaction is taken place. Undervalued transaction is taken place. And the liquidator or the RP, good evening, Namrata. Good evening, Viraj, not good morning. So where an undervalued transaction has taken place and the liquidator or the RP has not reported to the A. Remember, the responsibility casted is in the RP or the liquidator, and both have not disclosed that particular undervalued transaction. And a creditor, member or a partner of a corporate debtor, anybody, a creditor, a member or partner of CD, as the case may be, may make an application to A to declare such transaction void and reverse their effect in accordance with this chapter. So somebody else is coming to NCLT and saying that this is an undervalued transaction, and the RP has failed to recognize such transaction as an undervalued transaction. So the order will be given by the adjudicating authority, satisfied that the undervalued transaction has occurred, actually taken place. These are all small points which the court will consider. And the liquidator or the RP, having sufficient information or opportunity avail of such transaction, did not report such transaction to A. Did not report such transaction to A. Then it shall pass an order as under, restoring the position as it existed before such transaction, reversing the effects of the manner as laid down in 45 and 48. And then it may request the IBBI to initiate the disciplinary proceedings against the liquidator, as the case may be. So 47 is an application by creditor or a member, while 43, 45 is an application by the RP and the liquidator. By the RP and the liquidator. For an order for against section 43 is 44. For an order against section 45 is 48. For an order again an application in 47 is the order in 47 itself. Is the order in 47 itself. I hope it is clear. Any questions? Yeah. Then there is another section, section 49, section 50, where it has been mentioned that these transactions were deliberately entered. That means the intention was to defraud the creditors. That means the intention was malified. One was undervalued, where the intention was clear, but then they did it at a lower price. But here it was deliberately entered. Again, we have to prove that the intention was malified. And so obviously, accordingly, the order may be made, which is the same order. But very important, the order will again protect the interest of the person who are victim of such transactions. That means if there is a loss incurred because of this, the loss can be also be asked to be refunded or restored to the victims of such transaction. And then the last one is 50 PUFE transaction, extortionate transaction, where a credit transaction involving the receipt of financial or operational debt during the period at an abnormally different condition. So you are receiving a material at a very high price, and you are making a payment on the spot, cash payment, and purchasing material at a high price, or taking a loan at a very high rate of interest. These are extortionate transactions, which is unreasonable in nature. So that should not be done. So the order may be restored the position as it existed, modify the terms of transaction, set aside the whole or part of the debt created on account of that extortionate transaction, and can ask the party to repay the amount received by such person. And if any security interest was created as a part of this credit transaction, that should be relinquished. So this was all about PUFE transaction, friends. 43, 44, 45, 46, 47, 48, 49, 50. These are all part of your course content. Avoidance transactions, PUFE transactions, preferential, fraudulent, undervalued, whatever may be the term, it is one and the same thing. I hope it is clear. No questions on this. Then we had covered all these section 52 and 53. So what is the final stage, friends? What is going to happen finally at the end of the day once everything is done? Now there is one very logical thing, friends, regarding this PUFE transactions, going by the experience which I have. Suppose a resolution applicant has submitted a resolution plan, and simultaneously the RP has also filed a application under section, let's say 43 or 45. And the matter can go on for 2 years because it is a matter of what fraud at times, undervalued, you have to prove, there will be a counter argument. But by that time, the resolution applicant plan is voted upon by the COC and approved by the NCLT also. It may happen because that has to be completed within 330 days. It is never mentioned in the law that any application which is filed under PUFE has to be completed within 330 days. The CRB process has to be completed in 330 days, which does not mean that this application has to be completed in 330 days. So the cases under 43, 45 may keep on going, and it may be decided at a later stage. But what will happen if, let's say, the court decides that the person has to pay that amount? 10 crores of amount has to be paid because the transaction was undervalued. Who will take that amount? So the plan which is submitted by IRA may mention about it. And if it does not mention about it, then whatever amount is received in due course, that will be given to the COC, the creditors. That may happen. So while drafting that plan, the RA must mention about what you are going to do with that particular application which is pending. And you have to mention that that amount may be taken up by the COC. I'm not concerned with that amount. Or let's say I will take care of that case. I'll fight that case. And I'm going to pay a certain amount against those cases also. And let me see what can be realized. So these cases keep on happening, and maybe before finalizing the dissolution of the corporate debtor, these cases will be heard. Because once the dissolution order is given, then who is going to take care of that particular application and the amount which is going to be received in due course? So to that extent, probably the court will decide before they give an order of dissolution of the corporate debtor. So once everything gets over, where the corporate debtor assets have been completely liquidated, the liquidator will make an application to the A for dissolution of such corporate debtor. The adjudicating authority shall on application order that the corporate debtor shall be dissolved from that date of order, and the corporate debtor shall be dissolved accordingly. And copy of an order within 7 days from the date of such order will be forwarded to the authority with the corporate debtor which is registered, that is ROC. That is ROC. And let me tell you, liquidation is a big challenge, especially in those cases where the corporate debtor has made investments in certain private limited companies. And you have to sell that asset. That means you have to sell that particular shares. And you are not able to sell because there is no buyer for those private limited companies. So those are classified as not realizable assets, NRAs. What will be done with those not realizable assets? How they are going to be disposed of? how we are going to convince the court that how we'll treat those NRAs. A big challenge. A big challenge, friends. So a lot of practical issues. As I told you, it's a very exciting law. New law with still changes being proposed on a very regular basis. Even today, if you read Economic Times, there have been major changes which have been proposed in the IBC code with respect to approval of resolution plan and so on. So a lot of times it feels that whether the changes are actually not thought of, or when they were drafting a plan, they could not think of it. So as you must be understanding, it's a different kind of law with lot of complications, because each CD has a unique business model, unique way of doing business transactions, and a lot of people involved, stakeholders involved. So that is creating uniqueness in each case. And because each case is getting a customized solution, there could be n number of problems for which even the government had never thought of. And that is why there are so many amendments being brought in. So that was section 54, dissolution of the whole process. Now we come to the fast track insolvency resolution. Now, what does this mean? That means, is there a time period which is less than 330? The answer is yes. But obviously it applies to specific class of companies. So what are those specific class of companies? Let us see that. So if there's a corporate debtor with assets and income below an income level, which will be notified by the central government, which has not been notified so far, or a corporate debtor with such class of creditors or such amount of debt as may be notified by the central government, again not notified, or such other category of corporate person. So either it will be based on assets and income, or it will be based on the creditors or the amount of debt, or it may be based on the category of corporate person. Now, category of corporate person, that means today it applies to small company, that is a category, a startup, a category, an unlisted company, a category. But unlisted company, yes, there's a criteria of asset also. So category they have defined: small company, startup, and unlisted company with total assets not exceeding 1 crore as per financial statement immediately preceding the financial year. So today there's a lot of buzz and hype around the startup. And if you want to wind up that startup within a short period of time, because startup grow very fast and they should be allowed to close very fast. Isn't that a fact, friends? Because we know that 95% of the startup fail. So let them grow fast, let them close down fast. And fast track insolvency provides for that particular solution. So 55, 56, 57, and 58. These are the 4 sections which applies to the fast track insolvency companies. Time period completed within 90 days. So from 180, it has been reduced to 90 days. If it was extended for 90 days further, then extension is given by 45 days, but with a voting of 75% by the COC. And it will be done once. Remember again, this extension time portion, it is done only once. During this whole process, it is done only once. But at times I've seen the NCLT even may permit it because of certain reasons within its power. They can again extend the whole period. But as per law, it is given only once. The next is the PIRP process. Recently introduced, not recently, I mean about 2 years back, this was introduced so that the small companies get the whole benefit. And this was again introduced to bring in resolution of MSME enterprises and that too faster resolution, and with an objective of debtor in control rather than in creditor in control. Remember this word, debtor in control, creditor in control. CIRP and liquidation is creditor in control, CIC, while PIRP is more of DIC, debtor in control. So it's a pre-package. That means everything is pre-decided, but following the route of insolvency and getting more value for the stakeholders. Though this was introduced about 2 years back, but it has actually not taken off very well, which means you won't find many cases under this particular provision. And people are still apprehensive, especially the bankers. They are not aware of this process very much, and they are not very clear that how this process will result in, what will they result in. Otherwise, CIRP and liquidation, now the bankers are very well aware of the process. They know what could be the end result, and they have understood the pros and cons of the process, ifs and not ifs, and a lot of disputes have been resolved. So, but PIRP has not actually taken the shape for what it has been designed so far. So what are the conditions for the PIRP part? But before we go to the conditions, I think it's very important to understand a few questions, and then we'll take it in last, this whole process, because again, it's a separate process. Let me take a few practice questions, and then we'll finally go to the PIRP process. So practice question, we have around 12 to 13 questions to be solved, along with whatever has been asked in exams also. We'll try to solve those exam question also. The first question, let me see if you are able to grasp it. It's more of a case-based scenario, not MCQ. The RP of the company receives a request from the member of Committee of Creditors holding 30% share in the COC on 1st July at 5:30 p.m. to convene a meeting on an urgent basis to discuss matter relating to interim finance. We know section 28 where prior permission is required of the COC to enter into certain transaction, and one of them is raising interim finance. Considering the urgency and citing the reason, the request has come to convene a meeting. The RP circulates the notice of the meeting 2nd July in the morning itself at 11 a.m. During the meeting, other members of the COC are informed that the RP, that is action of convening the meeting based on the request received and the duration of notice, is not sufficient as per the provisions of the IBC. Discuss the validity of action taken by RP. So again, friends, let us segregate. If a case-based scenario comes, let us segregate. Yes, I think in my last class, I had given you a hint that how you need to approach a question, whether it is related to pre-CIRP period or a post-CIRP period. Pre-CIRP period, that means from section 3 till 12. And post is from 13 to 32, and liquidation is from 33 to 54. Now, because it is talking about COC, I would assume that it is falling under 13 to 32. So now your focus is between 13 to 32, right? So you're trying to converge upon a particular provision where I could try to get the answer from, get a hint that, okay, this is talking about this section. Now, so in post-CIRP from 13 to 32, again, very logically speaking, 13, 14, 15 or initial section would never talk of COC. COC comes into picture later on. If you are aware of the CIRP process, It is first the IRP, moratorium, public announcement, IRP taking over, and COC is considered after 30 days. So again, we are trying to converge that where should I get the hint. So COC is from 21 to 25, majorly. And 28 is a section giving powers to COC. So again, you are trying to converge, okay, from 13 to 32, I have to focus between 21 to 25. And when it talks about meeting, so we need to refer to section 23, 24, which talks about meeting. And remember, we had discussed that it is the RP who will call the meetings of the COC. That is the duty of the RP. But again, we have understood one of the provisions where one of the members of the COC can also call a meeting, but he should have a minimum holding that is 33%. That is 33%. Yes. Namrata, I'll answer your question. With Janvi, again, I think we are wrong. So 33% should be there to call a meeting. So that criteria is not met. So first problem, 33%. And second problem, remember, a notice of the meeting has to be given for minimum 24 hours in advance. Though normally time period is 5 days. Any notice of meeting has to be given for 5 days in advance, but it can be reduced to 24 hours subject to approval of COC. And if the COC consists of authorized representative, it should be minimum 48 hours. So here the second problem was convening a meeting within a very short frame of time, less than 24 hours, which is not allowed. So on both fronts, both counts, the RP is not correct in calling the meeting of the COC. Janvi, I hope you've got the answer now correctly. Namrata, extension of time period point. Normally the time period is 180 days, which can be extended to 90 days. This extension will be granted by NCLT only once. It will be granted by NCLT only once. That is the first thing. That means if I go for extension, I can go only once. And when I go once, I should take it for the maximum time. Let's say you have taken for 45 days. And then again, you approach NCLT to get extended by more 45 days. NCLT will say, no, you can come only once. So that is the rule. That is the section. I hope it is clear. But practically, I've seen that through the different powers of NCLT rules, they can further extend it also. The next question. Important part. Consider the following scenarios and examine whether the following resolutions stand approved in the meeting of COC. Appointment of valuers, 50%. This is an agenda and 50% is the voting. Replacement of RP, 67%. Approval of resolution plan, 52%. Withdrawal of application under section 12A, 85%. Appointment of technical consultant to assist, 56%. Now, appointment of valuers. As per regulation, as per law, valuers have to be appointed by RP, and even in required, liquidator can also appoint. That is given under regulation 27, read with regulation 35, no, though not in your course. But again, very important aspect. This whole valuation is a very important aspect, just to give you the reason why. As in COC, how we are going to judge that resolution plan. If that resolution plan is coming, how do I judge whether that resolution plan is good enough for me or not? There should be certain criteria of judgment of the amount which I am going to receive. So normally, the valuation reports submitted by the different valuers they create a base, an anchor price, anchor level, which could guide the COC that, okay, if the plan is above this valuation report given by the registered valuers, then there should be an acceptance, or even if it is below, you can take a call based on your judgment of valuation. So the value given by the registered valuers form a critical base in forming an opinion whether the plan should be accepted by the committee of creditors or not. So that is the importance of the valuation report submitted by the registered valuers. And who is going to appoint the registered valuers? It is the RP. Even in case of, let's say, liquidation, when you have to sell the assets, normally a base price is decided, because in a public auction, we all understand there is a base price, a reserve price. If you have heard of the term reserve price. So what will be that reserve price? From where do we get that reserve price? So we refer to the valuation report, and the valuation report, whatever is the liquidation value, that may be taken as the reserve price. Right. So when the appointment is done by, now who is going to appoint? Remember, the RP. But as I said, all appointment, cost, approval, they are taken by the COC. Now, with respect to voting, remember I had mentioned 3 percentages, 66, 90, and 51. 66, 90, and 51. 90 is in a specific case, 66 is again given in the law, and wherever nothing is given, then 51%. So as per regulation, it is mentioned that RP has to appoint valuers, but it does not say that you have to take a vote on that with a specific percentage. But obviously, we know that the cost has to be approved by COC. And when there's no mention of the minimum percentage, it is deemed to be 51%. But here it is mentioned as 50%. So wrong. It is not approved. The second scenario, replacement of RP. Replacement of RP. Can RP be replaced? The answer is yes. Again, a very important provision. Replacement of RP. Again, going to the overall process, friends. Remember, we had discussed IRP appointed by A. This IRP gets converted into RP. So if a new RP is replacing the old IRP, then the COC will vote with 66%. And they can replace the existing IRP with a new RP. Right. But here the question is replacement of RP. That means I'm trying to replace this RP who is appointed by another new RP. So the question is whether he can do that, whether the COC can do it or not, and if required, what is the percentage? So section 27, which we had not discussed, but a very important section, which talks about replacement of RP, not IRP, but replacement of RP. Yes, Mr. Kishan, if you have any questions, doubt, please raise your point. So replacement of RP, friends, section 27 talks about where at any time during the CIRP process, the committee of creditors is of the opinion that RP appointed under section 22. Now, who is the RP appointed under section 22? He is the from IRP to RP. That is section 22. RP is appointed in place of the old IRP. So this RP is required to be replaced. Who is appointed under section 22 is to be replaced. Then the COC may at a meeting by vote of 66% resolve to replace the RP appointed under section 22 with another RP subject to a written consent. In all the cases, remember, be it appointment of the IRP by an executing authority or under section 22 or under section 27, a written consent is must from the proposed RP. That means if I am the IRP, I will give my written consent. Yes, I am willing to act as a RP of this particular corporate debtor in a specified form, that is AA. And remember, every appointment, though approved by COC, but appointment is done by NCLT. It is only approved by COC. Appointment is done by NCLT. That means whenever NCLT comes, remember logically, NCLT by virtue of its own thought process will never give an order. You have to make an application. You have to make an application. So the COC shall forward the name of the IP proposed to the adjudicating authority. When it says forward, that means you have to make an application, and then the NCLT will review that application and give an order. Now this is the new RP. Till that time, the old RP will continue to work. Remember that the old RP will continue to perform his job. That is very clear. Let us go ahead. So here in our case, replacement of RP 67%. Agreed, yes, approved. Approval of resolution plan, again 66%. No doubt about it, we have already studied. Not approved. Withdrawal of application, remember, a very common question which is asked in the exam. Quite frequently asked. Can an application be withdrawn after it has been admitted, after the COC's form, before the COC's form? Remember all these points which we have discussed in our previous class. Please note it down. Section 12A. Quite commonly asked provision in exam in one form or the other. So 12A, 85%. Answer is no. 90%. Before you make an application, 90% voting is required. And then appointment of technical consultant, 56%. As I said, there's no voting percentage mentioned. Then 51 is the basic criteria, and therefore 56% is the approved one. Next question. Rohit is appointed as IRP of COCO Limited during the first meeting of the Committee of Creditors. First meeting, remember. He has stated that being a person from engineering background, he cannot ensure compliances under all the laws applicable to the company. Examine the statement made by Rohit in the light of provisions of IBC. Again, further, in order to achieve the objective of value maximization, RP of COCO Limited is contemplating filing an application against debtors who have not paid their dues from the last 1 year under Section 9. However, his lawyer has opinion there exists no provision under the court to initiate CRP against another company by a company which is itself going CRP. examine whether opinion of given of the lawyer is correct or not. Very challenging question, very challenging, but very easy. So if given a time, can you answer it? Can you answer the question? There are two parts of the question. First, being in from an engineering background, he cannot comply with the laws. So what should you do? Now again, as I said, please divide the question into three parts. Is this a question pre-CRP or post-CRP? So the answer is post-CRP. Now when post-CRP, again, because his RP is talking about, he is not able to fulfill his duties, section 1718. And we have understood, yes, can he appoint the compliance responsibility is casted on the IRP and the RP. And to comply with the various provisions, can he take support of various professionals? The answer is yes, he can take support of the various professionals. No doubt about it. There's no doubt about it that you cannot take support of the various professionals. So he can appoint professionals. He can appoint professionals by taking an approval from the COC. By taking an approval from the COC. But the next part, which I'm looking for an answer from your end. Janvi, you have given the answer, the first part correct. But remember, you have to, that's a state one, section 17. Under section 17, he has got the power to appoint professionals because he has to comply under section 17. He has to legal compliance's responsibility was on the IRP. So because of that responsibility, and he has given the power to appoint other professionals, subject to approval from COC. Subject to approval from COC. Now the second part, whether a company which is itself undergoing CIRP, can it file a case against other company under section 9 now? Again, this is a process relating to pre-CIRP because you're talking about application filing. Now, can I file a case against other companies which is under CIRP? So remember section 11, which was an exception prohibition that who cannot file an application for insolvency. A very important provision, section 11. Don't forget that. Don't forget that. Very important. So please ensure to read section 11, which talks about that I cannot file, that a company cannot file application for CIRP. But there's an explanation which was introduced, which is categorically mentioning under section 11, which talks about, yes, a company which is already undergoing a CIRP can file cases against other companies under IBC. It is specifically written there that a company which is under CIRP can file cases against other companies from which the amount is due. So the opinion given by the lawyer is not correct. Then we just refer section 11. Just refer section 11. Explanation to section 11. Explanation is given. So very important question, friends. Kindly note it. Section 11. Okay. Another question. Multibank Limited acquired 10% of convertible debenture in Oscar Limited. In terms of the issue in 2012, these debentures were converted into equity shares in Oscar. Consequent to conversion of Multibank Limited became the owner of 5% equity holding in name is Oscar Limited. Further, Multibank Limited provided a loan of 10 crore to Oscar Limited that became due in year 2018. The Oscar Limited became defaulter in repayment of loan not only to Multibank but also to some other banks. On the application of ICID Bank, the adjudicating authority initiated CIRP and appointed IRP. Committee of creditors constituted by IRP include Multibank and ICD Bank. Constituted by IRP include Multibank. ICDI Bank objected on the ground that Multibank is a related party that should not have any right of representation, voting, or participation. Examine the issue and offer our views. Now remember, again, is it 3 to 13 or 13 to 22? Can anybody refer? 3 to 13 or 13 to 22? 3 to 12 or 13 to 22? Is it pre-CRP or post-CRP? That is a question. First question which should strike in your mind. Pre-CRP, post-CRP, liquidation. Obviously, it does not talk about liquidation. That is out of question. So when it is talking about COC, it has to be post-CRP. Now, under post-CRP, is it talking about the responsibility of the IRP or the conduct of the process, resolution plan, approval, or is it talking about the COC, constitution, and so on? So it is talking about constitution of COC. Constitution of COC, correct? Now, when we refer to the constitution of COC, remember it talks about that the COC should be constituted only of the financial creditors, and that to the financial creditors should be unrelated. And related party has been defined under section 5 and 3, and that definition is quite an exhaustive one. So that means I have to refer to that section and find out whether that person Multibank is a related party or not. But here they are talking about relation only by virtue of a transaction where a convertible debenture has been converted into equity. So by virtue of this transaction, ICID Bank is mentioning that this bank is a related party because it has done this transaction and now they are the shareholders. Remember, we had discussed this point that a constitution of COC, related party will not be part of the COC. But if a relationship is on account of conversion of debt into equity by any provisions of any regulatory authority laws and notification, then that transaction will not result in establishing a related party definition. So if ICID Bank is objecting on this ground, then this ground is not valid because the law is categorically mentioning that this transaction is not to be covered while we are looking at the relationship between the COC members and the corporate debtor. So that is as per section 21. Remember, as per section 21. I hope it is clear, friends. Section 21. Any questions, anything which is coming to your mind, please raise your point. Correct, Jan. Absolutely correct. The next question. An OC of a company has made an application to NCLT for initiating for non-payment of dues for a long time. The NCLT ordered for this. During the course of CRP period, the CD has agreed to settle the dues of OC and requested him to withdraw the CRP. Whether NCLT may allow the withdrawal of application admitted at IBC. In the above case, will your answer differ if the above application is made by FC and the subsequently corporate data settled his dues? Okay. So remember again, it is talking about settlement and withdrawal. That means, should we go ahead after 13 section or before 13 section? So when I talk of pre-CRP, it includes withdrawal. When I talk of pre-CRP, it includes withdrawal. Great. So friends, just 1 second. So when I talk about withdrawal, remember there are different stages. Application filed, not admitted, the applicant can withdraw. Application filed, admitted, COC not constituted, withdrawn by virtue of powers of the NCLT. Application filed, admitted, COC formed, it can be withdrawn. Subject to approval from the COC to the extent of 90% voting in favor of the withdrawal. Application will be filed by, very important, remember, you have to complete the whole answer. It's not necessarily that you will close the answer that you need to get 90% approval and then the overall answer is correct. No, friends, that is not the end. You have to mention that the application will be filed by the applicant, not by the COC or the RP. The applicant will file that yes, they have taken a permission of the COC to the extent of 90%. Now I'm please withdraw the case. Now, whether there will be any difference if the applicant was FC rather than OC. So the law does not differentiate between the applicant or the OC and FC in case of withdrawal. In case of withdrawal, though in the application there are differences, section 7 and 9. But for withdrawal, the law remains same. You have to take an approval of 90% from the COC, which itself shows that COC, because it constitutes only of the FC members. So if the OC is trying to settle, then it is very difficult because OC has to come into the COC and convince the COC that I want to withdraw, provided you give the approval, where the amount of the FC have not been settled. Why would FC give the permission to the extent of 90% and okay, we agree that because OC has got the settlement is amount and therefore we also agree to this whole process coming to an end, which may be difficult. Unless the company is going concern and running and the COC feels that, okay, while running the company under the current situation will be more beneficial rather than taking the company into insolvency and dragging it along. And then I think this COC may give the permission. I hope you are getting the point. But anyway, in both the cases, the permission will be required. Great. Janvi, I'll just refer section 11 so that it is very clear to you. For everybody else also, section 11, under what scenario you cannot file application for initiation of CRP. So under this scenario, a corporate debtor who is already undergoing A corporate debtor who is already undergoing an insolvency, that means he itself cannot file an application against itself, not against others. It is not mentioned not against others. That means I cannot file an application which is already undergoing an insolvent process. Then again, I go and say that I will have to file an insolvency process against me. No. Or who has completed a CIRP process, already a CIRP process has completed. Or who has violated the terms of resolution plan. Or against whom the liquidation order has been made. Or a financial creditor which has violated the terms of resolution plan. An explanation says that nothing in this section will prevent a CD referred to in clause A to D from initiating CIRP process against other corporate debtors. Hope it is clear. Done with section 11. Okay, moving on to the next question. So these are very interesting case studies. It brings a lot many clarity in terms of understanding the section, provisions, and the major ones, and which are very tricky and quite commonly asked in exams. So this one we are done. The next. Naveen Kumar IFC filed an insolvency under section 7 against ABC Corporation on 1st July 2018. NCLT tribunal, after satisfying that default has occurred in all respect and all related compliances have been made, admitted the application by passing an order on 10 July appointing Mr. Kamal Kishore as IRP as per the IBC. State the following. Initiation date for CIRP. First question, initiation date. So what is the initiation date? Remember, initiation date is the date on which you apply, first time apply and file an application, 1st July 2018. Date of issuance of public, date of commencement of insolvency. When the order is made, 10th July. 10th July. No. Wait. Disconnect. So, till the first COC meeting. So we would write down that the tenure of interim resolution professional will be till the first COC meeting. And as per the model guidelines, as per regulation 40A, the first COC should be held within 30 days. So indirectly it means the tenure will be 30 days, indirectly. But what you have to mention till the first COC meeting. The last date for filing their claims, remember the time period. Oh, sorry, third part is date of issuance of the public announcement. So as per the model timeline, 3 days, within 3 days from the date of order, date of the insolvency commencement date, within 3 days, that means by 13th July. By 13th July. By 13th July. The last date to file their claims. Normally, as per law, when the public announcement is given, 14 days from the commencement of the insolvency. But as per regulation, an extended time period till 90 days is given. So here I have to write down 14 days, that is by 24th July. The claim has to be filed. But as per regulation, a further extended of 90 days time period is given to file the claim also. What is the time period for completion of the IC process? So you can count 180 days from 10th of July and accordingly write down your answer. The next question. ESI Limited filed CIRP with the adjudicating authority, which was accepted, and EOI was invited. One N Limited filed an EOI. It was noticed that N Limited was incorporated just 7 days before submission of EI as a joint venture between AE and other two companies. It was further came to the notice that AE Limited was completely held by Sawant Seth through various companies and a trust, and Sawant Seth was son of Ravi Seth, who was promoter of ESI Limited. You as a resident professional in this case, what would you suggest to the Committee of Creditors and Adjudicating Authority about the acceptance or rejection of the EOI? Give reasons for the same. Will not quote the case laws because law has changed a bit. But anyway, the primary purpose of discussing this particular scenario is the importance of section 29A. 29A. And remember 29A? Which gives the criteria for testing the eligibility of resolution applicants. So therefore, here we have to refer section 29A, list down all the rules, provisions of 29A that who are not eligible. So prima facie, because you would find that Mr. Sawant Seth is a son of Ravi Seth, who is a promoter of ESI Limited. So by virtue of that, he will not be an eligible person. But you need to write down the specific provisions. Then only you can mention it. And because Sawant Seth is a connected person of Ravi Seth, and Ravi Seth can fall under the criteria because the company has willful defaulter, or the account has been classified as an NPA, or there has been imprisonment, or they are subject to preferential transactions, and so on. And the connected person of Ravi Seth will also, if they come under any of the criteria, will also not be eligible to be a resolution applicant. Now, what does this mean? So here in this case, because he's a connected person to Mr. Ravi said, though they have applied in the form of a company, but then being a promoter of that company along with a joint venture, so even one of the person, other person may qualify, but even on the consortium basis, if any one person is not qualified, then the whole consortium will be not be qualified to apply as an applicant. So you have to refer section 29A, cite down the reasons, and remember in 29A, a connected person to who also falls under any of the eligibility criteria, non-eligibility criteria, will also not be eligible. But a very important thing, friends, which I want to discuss out here is section 240A. 240A, which talks about that the provision of clauses C and H of section 29A, C and H, that means A and B will apply. A and B is more of willful defaulter. In respect of CIRP process of any micro, small and medium enterprise. So this particular relaxation was introduced in 2019 or so, where a promoter can come and bid for his own company, provided that company is micro, small and medium enterprise as per the MSME Act. So even if he is falling under section 29A by virtue of 240A, except two provisions A and B, rest of the clauses will not apply of section 29A in a company which is a small, micro and medium enterprise. So if in exam, if the corporate debtor is classified as this, kindly refer to section 240A, which is a very important and relevant provision in the current context, where owner can come and bid through CIRP process, because this gives them the right of exemption from applicability of 29. So we have discussed two new provisions, 240A and 27. 240A and 27. An application for CIRP was filed by bank against SI Limited, which was admitted by NCLT, and IRP was appointed. The COC was considered. Ajay, who was a member of suspended board of SI Limited, was neither allowed participation nor any information considered confidential was given either by the RP or the COC. Ajay made a representation before the AA to attend the meeting and for information document. Will Ajay succeed in his claim for attending the meeting of the COC and obtaining information about the COC proceeding? So that means the suspended board, whether they're allowed to attend the COC meeting and obtain information about the COC proceeding, the answer is yes. Remember, we had discussed the provision where the RP has to send the notice of meeting to the suspended board. And when you are sending a notice of the meeting to suspended board, they have the right to attend the meeting of the board, COC, though they may not have the right for voting, representation and any say in the meeting, but at least they will have access to the documents which are being presented at the COC meeting. So that is as per section 24 and read with regulations. Right, friends? So here we take a small break and then further plunge into different questions which have been already asked in the exams. We'll refer to those papers, 2-3 attempt papers, to understand that what kind of questions are asked in the exams. And thereafter, we'll take up voluntary liquidation. And then in short, we'll wind up with the PIRP regulations, right? So we take a short break and join as early as possible. margins. So let us take up one very important question. I'll share the screen with respect to a practical question, and let us see how many of you are able to grasp that question. That is with respect to section 53. I hope the question is visible to everyone. So if you see this question, it talks about particulars relating to a company which has gone under CRP and then liquidation, and which mentions about realization from the sale of assets, that is 7 lakhs, and thereafter the details of claim from respective creditors is mentioned, from secured creditors to unsecured creditors, from income tax payable to cess payable to fees payable to RP, and expenses incurred by RP, workman's salary, and so on. So all these details are given. We have to state the priority order in which the liquidator shall distribute the proceeds. This question will give you further clarification for section 53, that how 53 is to be interpreted and how that can impact my calculation and distribution. Now, when we start looking at 53, if you recall, the first amount which is mentioned under 53 is towards CIRP cost and liquidation cost. CIRP cost and liquidation cost, correct? And that CIRP cost includes any fee which is payable to the RP or any expenses which are incurred to run the company as a going concern. That is the first amount. So here in our case, if you see, there are two amounts which reflect these two particular entries, that is 37,500 and 17,500. 37,500 and 17,500. So from here, the first amount which we are going to reduce is 37,500 and so the first amount, if you can see from the answer, 37,500 and 17,500. And thereafter we have the balance which is left to 6,40,000. Now from 6,45,000, we will pay equally ranking between secured creditors and workman's salary to the extent of, remember, last 24 months. Last 24 months. And here, point number 8 mentions about workman's salary for a period of 30 months. For a period of 30 months. So therefore, accordingly, what we have to do, we have to take a proportionate of 1,50,000 to the extent of only 24 months, not 30 months. To the extent of only 24 months and not 30 months. So now from 150, we move on to 1,20,000. So 2,50,000 to secured creditors, and then 1,20,000 in a proportionate of 24 months. So that adds up to total 3,70,000. 3,70,000. If you can refer to this, 3,70,000. So the balance now left is 2,70,000. From 2,75,000, we'll pay to unsecured financial creditors to the extent of 2 lakhs. And thereafter, the balance which is being paid to the government dues. Government dues. where government dues include income tax and cess, which is payable to the state government. So now we'll reduce this amount to get 35. So the balance which is now available is 40. Now remember, now we have 40 which is left, but our 53 says that to operational creditors, first is any other debts and includes operational creditor. So there's no operational creditor payment mentioned in the question, but for the workman part, remember we had paid only 1,20,000. 30,000 is still remaining to be paid. So that 30,000 here will be taken as a part of other debts. That is to be understood, friends. Whatever has not been paid is per priority under point number 1, 2, 3, 4. Because of certain limitations and conditions, the balance amount will be covered under other debts. Under other debts. So this 30,000 is covered under other debts, which now completes our total payment. The balance left is 10,000, which is to be paid to the equity shareholders. Which is to be paid to the equity shareholders. I hope this question further clarifies section 53. Now very clear, this whole process calculation part. Let me move on to another questions, few more questions which have been asked in the exams. So here, if you can refer to this question, which I am highlighting. Mr. J was proposed to be appointed as RP for the corporate insolvency process initiated against BMR. Mr. R, a relative of director of BMR Limited, is a partner in the IPE, Insolvency Professional Entity. Now remember, friends, I think we had discussed the concept of IPE. Just trying to recall IPE, the concept of IPE. As per law, initially, only an individual could be appointed as insolvency professional, IRP or RP. That was the initial law. Later on, the concept of IPE came into existence. Where we can create an entity comprising of insolvency professional and they coming together to form a entity known as IPE. The purpose of creating IPE, because of the nature, the magnitude and the time involved and the expertise involved in conducting the CIRP process, was found to be very complicated. Therefore, the government thought that it is better that if we allow the concept of IPE, so that the assignment will be given only to an individual. But then because he's a part of the IPE, that IPE can provide support services to this whole process with the expertise of other people and other people as an insolvency professional and other partners who come in different form as lawyers and consultants and so on. So to facilitate this whole process, IPE came into existence. So the appointment as an under NCLT order, it is given to an insolvency professional, but he being a partner of IPE, the whole process can be carried out by the IPE, but yes, it will be signed by the insolvency professional. And now the latest, which has been amended again, where it has been allowed to appoint IPE as the IP only, IRP. That has been one of the major changes in the recent times. Anyway, not going to discussion of all these provisions. But remember the concept of IPE. So here, R is a relative of the director of BMIR, who is a partner in the IPE. So whether Mr. J is eligible for appointment as RP or not. Now remember, for eligibility criteria, we have to refer Regulation 3. And we have already studied that what is the eligibility criteria for appointment of the IRP. And one of the more important criteria is that he should be an independent person of the corporate debtor. An independent person means whether he is eligible to be appointed as the independent director, and thereafter his firm should not be even an auditor for their company and should not be a lawyer or consulting firm to the corporate debtor for the last 5 years and so on. So here it is clearly proven that being a relative of the director of BMR Limited itself vouches or clarifies that being covered under the related party definition, therefore he is not qualified to be appointed as an RP for the conduct of CR. So we have to refer Regulation 3. Regulation 3, again a quite commonly asked question. So please do study this Regulation 3. Then another question comes in. The COC consists of financial creditors of 245 crores and operational creditor of 25 crore. They appointed a RP of Mr. P in their first meeting held on 5th September 2020. The RP issued a notice for a meeting to be held on 10th November to approve a resolution plan with respect to the management affairs of a company, but notice was not given to operational creditors. Meeting was conducted on 10th November, but a resolution plan was approved by committee of creditors by not less than 75% of the financial creditors referring to the provisions of IBC. Examine whether meeting was invalid as notice was not given to operational creditors. Whether resolution plan approved will be binding on all creditors and the corporate debtor. So remember, again, referring to section 24, read with regulation 18 and 19 of conduct 17, 18, 19 for the conduct of the COC meeting. It is a clearly laid down law that notice of the meeting has to be sent to A, B, C, D person, including operational creditor, only if the claim of that operational creditor is more than the 10% of the total debt being admitted by the RP. So if the amount of dues to the operational creditor is more than 10% of the total amount of claim, then only they will be allowed to be a part of the COC without any voting rights. Now here under this question, if you refer to total debt means aggregate of debt, including the debt of operational creditor also. It is not excluding the operational creditor. So amount of claim from financial was 245, amount of claim from operational was 425, which that means the total amount of debt is 270. And if you consider the 25 out of 270, which is less than 10%. So because the amount of debt of operational creditor was less than 10% of the total debt, so as per law, there was no requirement of sending a notice of COC meeting to the operational creditor. Hence the meeting was valid and there's no requirement. That's the first part. The second part is, if the resolution plan has been approved by 75%, is it binding to all the stakeholders? The answer says that all committee creditors' decision will be taken by vote of minimum 66%, especially in case of the approval of the resolution plan. And such action shall be void. And once the land plan is approved as per section 31, remember, it is binding on the corporate debtor, its employees, members, and creditors. It is binding on everyone. So this question was referring to approval of plan and binding of the plan on different stakeholders. Section 31 says that it has to be binding on every person. Let me open up a few more questions. See, the questions themselves gives more clarity, more understanding of the scenario. And the applicability of different provisions. Correct? So let me open up another provision. And this is the latest one, quite easy one. Just referring to the particular section. Now, very important, which will give us a different perspective. Argent Infrastructure Project Private Limited, a corporate debtor, is classified as SME under Section 1 of 7 of MSME Act 2006. It owes 60 lakh to its creditors. In view of the COVID pandemic situation, the CD was not in position to recover money from debtors, and therefore it commits default in settling dues to the sundry creditors. The company decided to go for a pre-packed insolvency process and accordingly took the following steps to initiate PIRP. The financial creditor of the corporate debtor, not being its related party, representing 66% in value of the financial debt due to them, proposed Mr. Pure, the insolvency professional, to be appointed as the IRP. The majority of the board of the corporate debtor made a declaration that PIRP is not being initiated to defraud any person. The members of the CD passed an OR approving the filing of an application for initiating PIRP. There were no further approvals obtained from financial creditors board on any other matter. Referring to the provisions of IBC, advised on the following matters: whether the act of financial creditors proposing the name of Mr. Pure is valid, whether the declaration made by the board is in accordance with the provisions of the IBC, and so on. So friends, here what we have to refer is the PIRP. PIRP. So let me go back to the presentation and make you walk through to the provisions of the PIRP, pre-package insolvency resolution process. So what does this PIRP talks about? Friends, Pre-package insolvency resolution process is a concept where it allows the small and medium enterprise to enter into a pre-packaged solution with the bankers, normally the committee of creditors, where they will approach the bank with a pre-packaged solution that, look, bank, I am here with this my proposal that I am going to pay you this amount, and let us enter into an agreement that I will apply for a pre-packaged insolvency resolution process at NCLT with an approval from you that you have agreed to this particular plan. And with this particular plan as a base plan, I will apply the NCLT. And through the process of NCLT, we'll take this approval. And during this whole process, there will be the RP who will monitor the whole process along with the committee of creditors, but me also as part of the whole process to carry on the affairs of the business. So it is another form of one-time settlement with the bank, with the proposal with the bank through the route of NCLT without delaying the process of value maximization and in a transparent, in a efficient manner. With an option given to the COC that during this process, they can always call for expression of interest from other buyers also, so that they can evaluate whether other buyers can offer a better amount which the corporate debtor itself is offering, so that it leads to more value maximization and in a transparent and time-bound manner with the approval of the court. And it's a pre-package. So everything is bundled, already decided, but with a legal process. This was introduced about 2 years back with an intention to promote insolvency amongst MSME industry. Therefore, the amount of default mentioned under this act, under this provision, is not 1 crore, but 10 lakhs. So if you have made a default of 10 lakhs, you are eligible to fall under this provision and carry on the process of PIRP. So this was an objective to bring in net the MSME industries because of the COVID defaults. Anyway, so let me make you go through the provisions. This is covered under 54 section, covering from 54A to 54, I think PQ, something like that. So there are about 15 subsection, 15 sections under section 54. Because though there are common process of the main IBC, but still there are specific process defined to the PIRP. So the condition is clear. There should be a default. Who commits a default? That's for sure. And who are eligible? Obviously, the company which is already undergone pre-package insolvency process during the period of last 3 years, it will not be allowed to again make an application. Or it is not undergoing a CRP process, no liquidation, and as per section 29A, it is eligible. Then specific condition, the financial creditor not being related party have proposed the name of IP to be appointed as RP for conducting the pre-package, and the financial creditor of the corporator not being related but representing not less than 66% have voted. Further, they have made a declaration that directors have made a declaration that the process is that the CD will file an application within a definite time period, not exceeding 90 days, once it is approved by the financial creditors. The intention is not to defraud. The name of the IP and the CDS partner SR, or at least 3/4 of total number of partners, have voted or passed the resolution. So very logical provision. Only thing is this one you have to mention. Remember that the application has to be filed within 90 days once it has been approved by the financial creditors. Before seeking an approval from the financial creditor, the corporate debtor shall provide such financial creditor with a declaration referred to in clause F of subsection 2. This is the clause that this declaration that I'll file within 90 days. There's no intention to defraud, something like this. SR has been passed. Very important. This point. A base resolution plan which conforms to the requirement under 54K. 54K lays down that what should be included in the base resolution plan. And any other information as may be specified. So, along with declaration and SR, the base resolution plan has to be submitted. So, the RP who has been proposed to be appointed as RP. So, once his name is approved, he will start his work. And he will prepare a report in such form as may be specified, confirming whether the corporate debtor meets the requirement of section 54A. So whatever has been laid down under 54A that they are eligible. So we'll submit a report, yes, they are eligible. And the base resolution plan conforms to the requirement to clause C of subsection 4 of section 54A, which says that it should conform to the requirement of section 54K. Finally, that means it should be fulfilling the requirement of 54K. And if the CD fails to apply within the 90 days, or the application is admitted or rejected by the A, till that time he will continue to work. But once that is done, the role of the IP cease. Now comes the application part. I'll cover only the important aspect so that we can't expect a very detailed provisions of this particular act in the exam part. So I'll refer to the important one. So application will be made. Obviously, with that, you have to submit all the documents, SR, declaration, written consent of the RP, and so on, and the information relating to books of account. So once an application is made, the A will, within a period of 14 days, by an order, admit the application or reject the application. And obviously, before rejecting, it will give the time period. Now, this is important. The time period for completing the whole process is 120 days. Remember, this is exam point of view, 120 days. So the application will be filed within 90 days as agreed from the financial creditors. Before getting the approval of the financial creditors, the RP is to ensure, the corporate debtor has to ensure to take a declaration, SR, base resolution plan, and all those conditions. Once it is done within 90 days, the application is to file proposing a name of the RP. once the case is admitted, then the whole process will be completed within 120 days. And what is going to happen? The RP shall submit the plan approved by the adjudicating committee of creditors to the adjudicating authority as per section 54K. And if there's no plan, then the pre-package process will come to an end. So once the order is done, moratorium will start, RP is appointed, public announcement will be given, and so on. Whatever has been read is with respect to 13, 14, 15, that will all apply. Very important. The duties of the board. So here, the management of the affairs of the CD shall continue to vest in the board. That is the first difference, remember. So we have to highlight the difference between this process and the other process. That is the CRP. So one is the time period, then the process of making an application, then the process of the CRP where the management will still lie with the suspended board rather than the RP. And therefore, if the management lies with the board, therefore they will ensure that the company continues to run as a going concern and the value of the property remains intact, and all their duties, statutory obligation will be fulfilled by the promoters, members, and their KMPs. Now, what is the role of the COC and the RP? So obviously, RP will just ensure the process of acceptance of resolution plan rather than running the company. So understand here the responsibility is less, and ensuring that the company remains as a going concern where the board, they know how to run the company, they continue to do that. And RP focuses purely in the resolution part. And so the RP within 7 days will constitute the COC. Within 30 days, that was in the normal process. Here in 7 days, that is another point of difference. Obviously, claim will be received. Based on the claim, the COC could be updated. And within 7 days, the COC meeting will be called. So that means 7 days, the COC will be constituted, and further 7 days for calling the meeting. That means in effect 14 days. Now the 54K, the crux, the major part here. Once the COC is formed, what is the major job of the COC? The corporate debtor shall submit a base resolution plan to the RP within 2 days of the commencement of the ICD. And thereafter, the RP will shall present it to the COC. The COC may provide the CD to opportunity to revise the base plan prior to its approval under subsection 4 or invitation of prospective resolution applicant at the subsection 5, as the case may be. We'll refer. Obviously, all the plan which is submitted, that should be in consonance with section 30, which talks about the requirement of the resolution plan. Certain points to be included in the resolution plan. Now, section 4, the committee of creditors may approve the base resolution plan for submission to the A if it does not, very important, it does not impair any claim owned by the corporate debtor to the OC. Very important. This is one of the important conditions of the resolution plan, that there should not be any haircut. When I say haircut, if the operational creditor is of 10 lakhs, they should be paid in full. No impairment should be caused to the operational creditors. One of the prime conditions of this base resolution plan, which is not there under CRP. Under CRP, it is up to them, whatever they want to pay. Even if they want to pay zero amount, subject to clause section 30, they are allowed, subject to clause section 30. Now, what happens if the COC does not approve the base resolution plan? Or the base resolution plan includes impairment. Then the RP shall invite prospective resolution applicant to submit a resolution plan to compete with the base resolution plan. And the manner and the criteria may be laid down by the committee of creditors. With the eligibility criteria and the evaluation of the resolution plan. The RP will provide all the details, and section 29A and everything will be applied. So the committee of creditors then will evaluate all the resolution plan presented by the RP and select a resolution plan from amongst. And when they think that the plan is better than the base resolution plan, such plan may be selected for approval under section 12. Now, suppose even the resolution plan is not considered for approval or does not fulfill the requirement of subsection 20. Then they can further lay down the condition that it will compete with the base resolution plan. One was purely, it is better, so it is selected. But when they find that it is not better than the base resolution plan, then they shall allow it to compete with the base resolution plan. When I say compete, that means they will be open for bidding. So one is better. If it is better, they will take it for approval. But if it is not better, they will allow them to compete. It is not like they will reject. So when they are allowed to compete, and one of them out of the resolution plan and the base resolution plan will be selected. And if there is no plan selected for approval, then the RP will make an application for termination of the CRP, the PIRP process. Approval is subject to 66% voting. That's very clear. So once the application is made to the A for the approval part, they will review it as per section 30, and then order will be given and section 31 will apply and so on. Now, the question is very important. If a company has undergone a PIRP or is undergoing a PIRP, can the COC take that company to CRP? So the COC at any time after the pre-package insolvency commencement date, but before the approval RP under subsection 4, as the case may be, by a vote of 66%, may resolve to initiate a CRP process in respect of the CD if such CD is eligible for the CRP process under chapter 2. That means that limit of 1 crore and everything will apply. So this particular decision will be taken by the COC. The RP will inform this decision to the A, and accordingly the A will give an order of conducting the CRP process. And then the whole process will continue of the CRP. So PIRP, the major points, friends, remember, the eligibility criteria first, the first concern. Then the process of filing the PIRP process, the power of the board, and approval, the time limit, obviously, that you have to remember, 120 days. And the important part is the process of approval of resolution plan, where a base resolution plan is considered. Thereafter, if the COC thinks that it needs to call for other resolution plan, they may call for it. If it is better, they may go for approval. If it is not better, they will allow to compete. Out of that competition, which is better will be taken for approval. And if there's no such approval, the PRP process will come to an end. And if the COC thinks that they should be taken into CRP, the COC can take that decision. So this is PIRP. So one question was asked in the last attempt, or I think in May 2022, that was in relation to the PIRP, a straightforward question which we had just discussed a few minutes back before starting with the understanding of this PIRP process. And last, let us take voluntary liquidation. So friends, under this whole process of IBC, now you have becoming more knowledgeable in terms of certain technical words in a new world. PIRP, CIRP, liquidation, preferential transaction, waterfall mechanism under section 53, voluntary liquidation, resolution plan, resolution applicant, COC. So what does voluntary liquidation means and why it is required? Friends, there are so many companies in India. Out of, let's say, 24 lakh companies which are there, about 10 lakh are, about 9 to 10 lakh are inactive companies. No business operations are being carried on. Some of them are striked off companies. Now, as a owner of the company, I want to close down the company. I don't have anything in the company. It is simple, no assets, no liabilities except a bank account, and that's all. Or there may be scenarios, there are assets, no liabilities. I just want to close down a company. So I can strike it off. That's it. I can strike it off, follow the provisions of striking off and get the company striked off. Or, the concept of dormant company also, that can be applied. But what if I want to close down? Because striking off, it can be, recalled. There's a provision. You can again come back to the register of members or register of companies. So what you want is that complete closure. Where there's no default. There's no default, but I want complete closure of my company. So IBC provides for that particular route of closing down a company on your own when there is no default. First condition is there is no default. Or the time period for which the event or the company was created, that time period is now over. So the article calls for that now company should be closed down because 10 years have passed by and the company was formed only for 10 years. So what is the process? The process is a declaration has to be made. A declaration has to be made from the majority of the directors of the company, verified by an affidavit stating that they have made a full inquiry into the affairs of the company and they have formed an opinion that the company does not have any debt and it will be able to pay its debts if the assets are realized. So there are two things. There are no debts, or even if there are debts, we have sufficient assets to pay off the debts. While in CIRP, in insolvency, there was a condition where the assets are not enough to pay off the debts. And obviously, I'm taking this step not to defraud any person. That's a standard one, even in PIRP, that was a condition. So when you make a declaration, it has to be accompanied with the following documents. Namely, we have to submit an audited financial statement for the previous 2 years and for the period since its incorporation, whichever is later, along with a valuation report of the assets of the company if required from a registered valuer. So if there's a land or a building or a plant in the assets of the company, we need to take a valuation report from the registered valuer. That's a must. So declaration coming from the majority of directors along with certain documents. So once you make a declaration, we need to pass a special resolution within 4 weeks. Or a resolution of the company in a general meeting requiring that the company to be liquidated voluntary, either of the two, SR or a resolution. So procedure, declaration, SR. If there are creditors, approval of the creditors. Who will going to approve the resolution passed by the members within 7 days. So what you have to do, conduct a board meeting, provide a declaration. Then within that board meeting, call for the meeting of the members. Get a SR passed or resolution passed. That resolution to be presented to all the creditors. That means a meeting of the creditors to be followed by within 7 days. Along with that, please notify to registrar and the IBBI that we are going for this voluntary liquidation. And thereafter, once you get the approval of the CEOs, the creditors, within 7 days of that, you have to file. And remember, the date of passing of SR is considered as the commencement of the liquidation proceedings. Obviously, that will be subject to the approval of creditors. So here, if you see, there is no role of NCLT coming into picture. That means we don't need to go and apply to the court and asking for that let the company be admitted towards liquidation directly. There's no CRP process. Directly we jump to liquidation. And there's no requirement of approaching the court. That is why it is one of the best processes to close down a company without the intervention of any court. It's a voluntary exercise taken by the company. Follow the process, go to the appoint a liquidator, and then the provisions of liquidation from section 35 to 53 will automatically apply. So it is only that the liquidation order is not given by the court but by the members subject to approval of COC, and the liquidator is appointed by the members rather than the NCLT. Thereafter, the job of liquidator will be same. Call for the claims, comprise of the liquidation state, realize the assets, distribute the amount to the creditors, and file for dissolution of the company. That process will remain same. So if you see, there are many exercises, many companies which have now gone for voluntary liquidation. Many companies. And yesterday, in the last class, I had shown you the website nclt.gov.in. Go to that NCLT website or go to the IBBI website where the details of all the companies which have come under insolvency, be it under CRP, liquidation or voluntary liquidation, the list is available. And you will find daily one notice being uploaded at IBBI, public announcement being uploaded at IBBI calling for claims from all the creditors, and the company is company is undergoing voluntary liquidation process. Because though a time-consuming process, it's not that easy, because at times it becomes complicated, especially when it comes to government use, because you have to take NOC from the government also before finally closing down the company. So that is the biggest challenge. So apart from that, small minor challenges, and then the process is a streamlined process. So voluntary liquidation has again gained momentum, especially those foreign companies which was formed and now they think that they don't want to run the business in India. Primarily because of that reason, I think this has taken recognition in this world, where all those small private limited companies which were formed for certain reasons, but now that purpose is over, so they want to close down the business. So this is the whole step of voluntary liquidation. So friends, with this we have covered every aspect of IBC, covered maximum questions, exam questions, and the major provisions which are relevant from exam. So if you go through these slides along with study material and the practice questions, more than sufficient for your exams. I'll be uploading all the notes from tomorrow, so you can download the same. But I would always suggest that please refer the study material before appearing in the exams, because they are quite helpful. Understanding the law is by going through the lecture. Referring to the material is for reference and better understanding of the WARE Act. So that's all from my side. If you have any questions, you can raise it. So thank you all the students. This being my last class, so Janvi, Mansha, Viraj, Namrata, who have been here raising questions from time to time. So thank you all, and remain connected over any social media. The best way to connect through LinkedIn, and wish you all the best. Thank you. Sir, we can close